Hello, everyone, and welcome to Uncivil Law. For today's case, we have the case of Ronald Shell versus Burlington Northern Santa Fe Rail Company. This case deals with discrimination on disability, but the question at issue is with an expected future disability. Burlington Northern did not give a job to Ronald Shell because he was overweight. Although he was not experiencing any health problems at the time, the company felt that he might experience health problems in the future, and on the basis of this speculation, denied him the job. Ronald decided to sue under the Americans with Disabilities Act. However, the court found that under the statute does not protect anticipated or future disabilities, only current disabilities. So we're going to read the statute and see how Ronald Shell is not protected by this because he is not yet disabled within the meaning of the law. So let's get started with this. Burlington Northern Santa Fe Rail Company refused to hire Ronald Shell solely because it believed his obesity presented an unacceptably high risk that he would develop certain medical conditions that would suddenly incapacitate him on the job. Shell sued BNSF under the Americans with Disabilities Act, alleging that BNSF discriminated against him because of a disability. Ronald Shell began working at Chicago's Corwith Railroad in 1977. Shell occupied different positions in his 33 years at the rail yard, including as a groundsman, driver, and a crane operator. All indications are that Shell was a productive and skilled employee. Shell applied to work as an intermodal equipment operator. Upon reviewing Shell's application, BNSF extended a conditional offer of employment. One of the conditions was that Shell pass a medical evaluation. A physical exam then revealed that Shell was 5'10" and weighed 331 pounds, translating to a body mass index of 47.5. BNSF does not hire applicants for safety-sensitive positions like the one Shell was applying for if their BMI is 40 or greater. People with BMIs in this range are considered to have Class 3 obesity. BNSF says the reasoning behind its BMI policy is that prospective employees with Class 3 obesity are at a substantially higher risk of developing certain conditions like sleep apnea, diabetes, and heart disease, and unpredictable onset of these conditions can result in sudden incapacitation. So here BNSF was hiring for a safety-sensitive position. As a result of this, it didn't want to hire someone who might have sudden undue health risks due to weight issues. And as they point out, any BMI over 40 is considered the highest category for BMI purposes. And this guy had a BMI of 47.5. So he's well over the BMI of 40. So he was not eligible according to BNSF's criteria because of concerns of his future unexpected or sudden health issues. Applying BNSF's BMI policy, Dr. Gerard said that Shell was not medically qualified for the job. BNSF informed Shell of his disqualification, but told him his application could be reconsidered if he lost at least 10% of his weight, maintained the weight loss for 6 months, and submitted further medical evaluations if requested. The company argued Shell did not have a disability within the meaning of the ADA because his obesity was not a qualifying impairment, and no evidence suggested that BNSF regarded him as having such an impairment. In the alternative, BNSF asserted that even if it refused to hire reflected discrimination, its policy fit within the business necessity defense. So under the Americans with Disabilities Act, among other things, you can discriminate if it is necessary for a business purpose. So it only requires you to give reasonable accommodation and also allows you to discriminate if it would be a need. So they're arguing both things. First of all, it's not discrimination because the condition he has doesn't qualify as a disability, and even if it does, it's necessary for our purposes. So that's two arguments they're making. At BNSF's request, the district court certified its order for interlocutory appeal. The ADA generally prohibits conferred employees from discriminating against job applicants on the basis of disability. To prove violation, a plaintiff must show that he is disabled, he is otherwise qualified to perform the essential job functions with or without the reasonable accommodation, and an adverse job action was caused by his disability. So under the ADA, it has to be shown that you can perform the job despite your disability with or without the accommodation. Okay, fair enough. The statute defines disability as a physical or mental impairment that substantially limits one or more major life activities, a record of such impairment, or having regarded as such an impairment. Paragraph 3 entails that someone being regarded as having impairment when he or she is subjected to an action prohibited under this chapter because of actual or perceived physical or mental impairment, whether or not the impairment limits or is perceived to limit a life activity. So all that is basically saying that regardless of whether or not you actually have the disability, if you're perceived as having the disability, that's enough. If they're discriminating you on the basis of the perception, even if it's not true, that still counts as a discrimination on the basis of the ADA. Our decision in Richards v. Chicago Transit Authority foreclosed the weight-based argument for Shell. We held that obesity alone is not a physical impairment under the ADA unless accompanied by evidence that obesity is caused by an underlying psychological disorder or condition, and Shell has presented no such evidence. So being overweight alone is not considered to be a disability within the meaning of the ADA as far as the Seventh Circuit is concerned. Shell instead based his disability on those medical conditions that BNSF feared he would develop: sleep apnea, diabetes, and heart disease, which undisputably qualify as impairments under the statute. The wrinkle, though, is that he did not have any of those impairments at the time he applied to work, and the company held no perception to the contrary. All this narrows and lends precision to the question before us, where the ADA, regarded as prong, covers a situation with the employee views as an applicant as a risk for developing a qualified impairment in the future. We hold that it does not. So as we said above, here the court says the ADA only applies to currently existing disabilities, not future disabilities. So the court says that there's no protection for things that might happen in the future. We find ourselves in good company with this reading of the ADA text. In Morris versus BNSF, the Eighth Circuit came to the same conclusion on similar facts. BNSF denied Melvin Morris's job application for the same reason it denied Shell's. His BMI was over 40. The Eighth Circuit explained the plain language of the ADA prohibits actions based on existing impairment or perception of existing impairment, but the ADA does not prohibit discrimination based on perception. The physical characteristic, as opposed to physical impairment, may eventually lead to physical impairment as defined under the Act. All other circuits that have confronted this issue agree. The disability definition in the ADA does not cover this case where an employee perceives a person to be presently healthy with only potential to become ill and disabled in the future. With only proof that BNSF refused to hire him because of a fear he would one day develop an impairment, Shell has not established that the company regarded him as having a disability or otherwise that he is disabled. Absent this showing, he cannot prevail on his claim, and BNSF is entitled to summary judgment. So that is the end of the case of Ronald Shell versus BNSF. In this case, we learn the Americans with Disabilities Act only covers currently existing impairments, not future impairments or one thought to incur. And we also learned that the Seventh Circuit had previously held that weight alone by itself does not qualify as a disability. So if you're overweight and they discriminate against you in the Seventh Circuit, that does not qualify as discrimination on the basis of a disability. Seventh Circuit says lose some weight, unless of course you have some sort of condition that precludes you from doing so, in which case you would be covered by the ADA, but mere weight alone is not sufficient. Here, the court held that BNSF was able to factor his weight into consideration and was able to be concerned about future health concerns, particularly given the security nature of the job that he was applying for. So that is the end of this case.